Sue Ann Robinson in Florida. Sue Ann, thank you so much for joining me this morning as a guest legal analyst. Tell me, let's just start with your overall impressions of the prosecution's case now that they've rested, and whether or not you think they have proven these charges against Kimberly Potter beyond a reasonable doubt.
I think that the prosecution did a good job in terms of proving the case as charged. Definitely the second-degree manslaughter. We cannot forget that these charges do not require intent. And so the state needs to demonstrate, obviously, that what she did was reckless, that it had collateral damage, and most importantly, hone in for the jury that, listen, this is a 26-year-old veteran. This is not a rookie. She's not new to stress. She's not new to stopping people. She's not new to even being a training officer. So for her to just say that this was a mix-up is a stretch. And even if it is a mix-up, it's a mix-up that was so reckless that criminal liability should attach. And I think they did the best they could with what they had. I think the defense is today's purpose with having Kim Potter testify is to play on the jury's sympathies and to play that video of her being so remorseful and to just hope and pray that the jury says, well, she was remorseful for what she did, so maybe she shouldn't be accountable. I don't think the law works that way, and I hope that the jury sees through that and understands that listen, good people can make mistakes, and I think that's where the prosecution has to go in their closing.
And I think a lot of people would say good people make mistakes, but there are consequences for those mistakes, which I think, to your point, is what you believe the prosecution has proven in this case. Let's do a little bit deeper dive into the charges. So we know there's the first-degree manslaughter, second-degree manslaughter. The first degree involves the recklessness that you mentioned. Second degree, though, is a negligence, culpable manslaughter charge against Kimberly Potter. So let's just say, what if she gets up there, in your opinion, and testifies and says, well, it was a mistake. I did it. I did pull my gun accidentally. I meant to pull my taser, but I know that when I pulled my gun, I shot and killed Daunte Wright. If she says that, do you think it affects a jury finding the legal elements? Again, the state has the burden of proof, as we know, the legal elements of the first-degree manslaughter.
I think the legal elements are there. I think the issue is going to be the story for the jury because of the context. It's very, very difficult for her because her own defense has introduced all these character witnesses, spoken about how she was an amazing police officer, never had any issues, so incredible on the job that she was actually a training officer. So then when you set her up on a pedestal that high, and then she comes in and testifies and says, I made this mistake that caused someone to lose their life and then injured other people because in the moment I thought this was the safest response. There's a conflict there. It's hard for her to play the card of 26-year-old perfect record veteran, but then also say, in the moment, I made a call so horrible that Daunte Wright lost his life and someone else was injured and the car rolled into someone else and caused another car accident. And I thought that was the best thing in the moment. It's hard for her to say both things. And so that's why I think that for the defense sticking to, a good person can make a mistake and the state arguing that as well is almost their best bet. And then relying on the jury to apply the facts in the law for the state is what's going to keep the day for them. For the defense, it's really going to be the sympathy. It's really going to be them saying, ooh, good people, she's a good person, she's a great officer, and she made a mistake. It's hard as you're showing the pictures of the taser and the gun. Even logically, they're different weights, there's different ways in which they're deployed. We all see on the video that it's black when she's holding it and saying taser, taser, taser. So we're all watching the video saying, well, if a taser's yellow, can she not see that it's, a black gun? So it's going to be interesting today. I honestly think the experts today are going to work against her defense because now they're getting into an area where they're trying to convince the jury of something that, they would have to believe themselves that, these type of mistakes can happen. And they're going the extra mile to put science behind it. I think it's so tough for the defense because their case, to me, seems like a confusing mess because either it's a mistake, either it's justified, either Dante Wright is a bad person and deserved it, or this scientific issue happened to her brain and she thought the taser was a gun in the moment. It has to be one or the other, but it seems like they're just throwing everything against the wall, which is what, the defense is going to defend, but it makes it very difficult for the jury to grab onto a theme. And I think the state has had a consistent theme from the beginning. She may be a good person, but she made a mistake and she should be accountable for that.
And I don't know that we have time to play it, but Judge Chu, though, as the result of the prosecution's state, let's just remember that they did have evidence, and I think it went a little sideways on them because one of their own witnesses, as you may recall, Sue Ann, said that they felt that, in his opinion as law enforcement, that it was appropriate for her to use her firearm in that circumstance. And so then we know that the state came back with the professor as a use of force expert, and he testified that it was not appropriate use of force. It was not reasonable in those circumstances for her to have used a taser or for her to have used the firearm. And so Judge Chu talked with the attorneys about a use of force instruction that she now is going to have to give the jury. So I also want your opinion on really how important now these jury instructions are going to be to ensure that they have all the proper law in front of them so that they can then determine the facts as they find them and apply the law to those facts.
Well, Judge Wilcott, as you know, the jury instructions are really the most important thing after selecting the jury, because that's the jury's book, their rules, what they have to play by, and what they're going to have to apply the facts to. So the jury instructions are going to be the most important thing. So I'm looking forward to the use of force instruction and how it's going to be read to the jury, because I think it's going to be pretty critical.
Absolutely. I don't disagree with you. All right, Sue, and you're going to stay with us. We do need to take a break. Up next,